Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, lovely people. Thank you so very much for sticking around. It's another opportunity for us to meet on the program, The Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors is on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening, and you can contact them on 0208 493 7340. And as I mentioned, by their courtesy, we're coming your way with another edition of the Community and the Law. My name is Ulriku Frimpong. This afternoon, we are going to go a little beyond what we have always been looking at. Skilled worker migrants here in the UK. You are in here on a contract, and then you have qualified to apply for indefinite leave to remain. What are the requirements? How do you go about that? This afternoon, our friend and a lawyer from BWF Solicitors, lawyer Charles Asma, will be taking us through those steps and what the requirements are. So I want you to get ready, sit back, relax, and enjoy the journey, the community, and the law. Now, let me take you through our social media platforms and then to tell you what it is that we have up our sleeves next. Yes, thank you very much for sticking around. Yeah, I told you that we're going to look at our social media platforms, and we have the handles I've been showing you. But let me also welcome you to our YouTube channel, which is BWF Solicitors, our Facebook channel, BWF Solicitors, and also BWTV UK, both on YouTube and on Facebook. Those of you who have just joined us, announce yourselves and also like the page. And of course, get people to get to know that we are live. So share the page. And when you have done that, announce that you are here so I can acknowledge you and get those mentions as well. Well, we start off with the exciting news earlier in the week where we celebrated the birthday of Abigail Appiajan, a support staff. You always come to meet her with that wonderful smile at the reception. And this week we celebrated her birthday. So happy birthday to you, Abigail. May God grant you all your wishes. May your smiles continue to be with us as long as we are part of the BWF Solicitors family. Congratulations on your new age, and may the rest be as fruitful as you want them to be. Congratulations, and we celebrate you as well. When you have the party, please invite me. I'll come with all the other members of the team. Thank you very much for making us part of your life and also helping us to enjoy the day you celebrated. Ernest O also says that yes, we have had outstanding service from BWF Solicitors, and he has given us the, as we would say, shout out. I'm extremely grateful for the excellent service provided by Lawyer Annie of BWF Solicitors from start to finish. She was professional, approachable, and highly knowledgeable. She took her time to explain everything clearly, kept me updated throughout the process, and also responded promptly to any questions I had. Her attention to detail gave me confidence at every step of the way, and the outcome was excellent. I truly felt supported and well represented. Outstanding service, he says. Ernest, thank you very much for appreciating our very own lawyer Annie. And also, I would encourage you to advise people to contact BWF solicitors when it is that they need support for any of their legal matters, especially when it comes to immigration matters. So those of you who haven't experienced that, our contact are as follows. BWF solicitors 0208 493 7340. 0208 493 7340. If you're in Ghana, we have an office in Ghana, and it's on 055 589 5959. 055 589 5959. In emergency situations, call 044 77 127 61884. 077 127 61884. BWFsolicitors.com is our website. You go in there, all the assets and the facilities you need to be well abreast with all the things happening, and also our contact details as well. So contact BWF Solicitors, as I said, 0208 493 7340. Let me give you the social media platforms and the handles again. Then I'll go on to our nugget and then bring on our lawyer friend and, of course, our resource person, Lawyer Charles Asma, right after this. Yes, thank you very much for sticking around. So catch us on YouTube, Facebook, LinkedIn, and all the other platforms at BWF Solicitors and at BWTV UK. Did you know that there's an exception for those who have stayed for 14 days or less and sometimes a few days more? If your visa expires while you are still in the UK, you will become an overstayer immediately. However, there is an exception contained in paragraph 39E1 of the immigration rules. This exception means that you may still be able to make an application for leave to remain subject to both of the following conditions, so pay attention. A, you must make the new application within 14 days of the expiry date of your previous grant or leave. And B, you must have a good reason why the application could not be made on time. I will just pause on that one and do my formal introduction where I bring on board the resource person for today, Lawyer Charles Asma from the stables of BWF Solicitors. Asma, good afternoon.
Good afternoon.
Thank you very much for joining us this Saturday afternoon. Well, you look good. I love that.
Thank you.
Whoever sold this for you, please, you owe me one because I need to wear the same thing to look as good as Lawyer Asma. How's the work being, Lawyer Asma?
Yes, we aiming higher to make sure that we use the law to support the community.
Okay.
And as many reviews and feedback and positive responses that we're getting from
That's
our
right,
clients suggest that God has been good.
God has always been good. Well, and yes, I read earlier on the appreciation shown by Ernesto. But yes, he is praising Lawyer Annie and the family. And we believe that, as you said, use the law to support people. And one person has also shown appreciation. Outstanding service, they say you provide. Thank you very much. But then we had those, and I was asking people whether they knew that there was an exception for those who have overstayed for 14 days or less. And we have seen those two conditions. One must make the new application within 14 days of the expiry date of their previous grant of leave. And also, they must have a good reason why the application could not be made on time. I want you to help us expand on this, especially the second one that says you must have a good reason. What could be a good reason? Maybe you take us through it.
Yes, viewers and listeners, so we are looking at paragraph 39E. Most of you are aware of section 3C, and a lot of other people also are aware of paragraph 39E. 39E, 3C. 3C, we know that it says protection, overall protection. 39E, temporary amnesty. What do we mean by temporary amnesty? So the rules are clear that if you have a limited leave to remain in the UK, you have to apply to renew your visa if you wish to continue to remain in the UK. And such renewal should go before the visa expired. And so the visa, you must have an exempt leave, or we call a valid visa, before you send your application for renewal. If by the time you submit your application, the visa has already expired, then you are an overstayer. The question is, as an overstayer, can I apply to still renew if I have a reason to explain why I became an overstayer before applying? Paragraph 39E has room for that maneuver. Simply, if your visa expires today and you apply to renew within 14 days of expiration or the visa expiring, you are protected under 39E that you can still apply even though the visa has expired. So it's your fault. But the question is, some mistakes are pardonable, some faults are excusable. And so you must bring that reason why you had to apply late. And that is what the second limb of the rule say, that you must have a good reason why you are late in bringing your renewal application. What is good reason? A good reason is one that will make sense to an objective bystander. So there's something called Wensbury reasonableness. Mm-hmm. And under the Wensbury reasonableness, the objective bystander's assessment is if the person who has no knowledge, who has no understanding, and who is not aware of the conversation, having been told about this, can conclude that, this makes sense, then it is a good reason. And therefore, example, why were you late? I was hospitalized for the whole time. I was discharged today, and I told my lawyer to apply for me. Is there evidence that you were hospitalized? And on that basis, there was nothing you could have done to renew before it expired. If that's the case, it's a good reason.
It's a good reason. Okay.
Were you in any situation that made it impossible to instruct your lawyers to apply for you or to put in the application yourself? That may be a good reason. For example, somebody will say, well, I know I could afford, so I had only £500 difference to be able to pay for the application fee. Unfortunately, that £500 I had to get from a friend. The friend kept promising me, by the time I got the money, I've run out. Okay. Is that a good reason? Potentially.
Potentially, okay.
So all that would suggest that there was nothing you could have done. And therefore, you have to be considered to bring the renewal application within the 14 days following the expiration of your visa. And once you submit, so the catch here is that you don't just apply because you are within 14 days after expiration of your visa. Mm-hmm. You have to also provide reasons why you didn't do it on time.
Okay, so as lawyer has explained, if your visa expires while still in the UK, you definitely have become an overstayer, but those two conditions must be met. You must make the new application within the 14 days and provide a good reason why the application could not be made on time. And he's giving us a few examples of what some good reasons may be. Others may be looked at. So what I would suggest is consult a lawyer who would help you weigh your decisions and reasons, and then you make an application. And I would recommend that you speak to BWF solicitors. You can contact them on 0208 493 7340 0208 493 7340. Those in Ghana 055 589 5959 055 589 5959 or 04477 127 61884. Get to all the social media platforms and DM them and they will respond to you and help you as well. Okay, so having had that explanation, let me see if I can test your knowledge on the nuggets and also some of the knowledge we have shared. Agatha Mumford came to the UK as a skilled worker with a visa for 3 years from 2023 to 2026. She received an email on June 21 from the Home Office stating that her visa had been revoked. Her visa was cancelled to expire on 21st August 2025, 60 days. Before this cancellation, she had received a conditional offer from the NHS pending completion of pre-employment checks. She received a COS from the NHS on the 4th of September. Can she apply for further leave based on the COS despite her visa expiring on 21st of August? I've given you three options, so choose one and provide me with that. Yes, because the NHS is a government employer, so its employees covered. No, because a visa was cancelled to expire on 21st of August, so she is an overstayer. And yes, because she made her application within 14 days and she had a good reason for the delay. Think about this and let me know which answer you think is correct. After this break, we'll go into the discussion. This afternoon, we're looking at CEO, the indefinitely to remain, so to speak, application requirements for those on skilled worker route. So if you have a skilled worker migrant and you are applying for indefinite leave to remain, what are the requirements? How do you do that and what steps do you follow? Lawyer Charles Asma will be taking us through that. And remember, we're doing this courtesy BWF solicitors, our trusted partners when it comes to the law. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you very much for sticking around with us. For those of you who have joined us on Facebook and YouTube, let me quickly acknowledge you and welcome you on board. Kwame Atajima, oh, it's been a long time. This is a name we work with all the time. Kwame Atajima, where have you been? Thank you so very much for joining us and welcome back to the show. Ade Terrible says good afternoon to everyone. Good afternoon to you, Ade. Sandra Fraser, good afternoon, says. Good afternoon, ma'am. Thank you for joining us. We're excited to have you on board as we share valuable legal insights and updates. Would love for you to share a program with your friends and family who might benefit from it. Your support means a lot to us. Let's stay connected and learn together. Thank you, Sandra. Happy birthday to Abigail. Yes, we celebrated you earlier. Happy birthday to you. Share when you join, please. Ade is urging us on to do that. Now, we're going to look at indefinite leave to remain application requirements for skilled worker migrants. Question is, those of you who are migrants and you are skilled workers, you have a contract period. Yes. Does it lead to indefinite? We'll ask. If it does, when it is that your time is up for you to apply for indefinite leave to remain, what do you need and what steps do you need to follow? Last one. I will throw the ball into your courts at the moment and help us to unravel this.
Sure. Thank you once again for joining us, viewers and listeners. The conversation, someone will say, is bespoke, specific, and direct to people who are seeking to apply for indefinite leave to remain because they came to the UK as skilled worker migrants. So this conversation, of course, you have question. The question could be about anything and everything. But for this topic, we are meeting specific needs of people who came as skilled worker migrants and are due for indefinite leave to remain or are planning to apply for indefinite leave to remain. And we're looking at what requirements or things they have to consider or bear in mind so that they will not be taken by event. So skilled worker, migrant, due for indefinite leave to remain, what does the law say? What do you have to do? And how do you avoid getting refused? So we are looking at the standard things which affect every application. Suitability. So suitability, you have to remember that if you are applying and you lie on the application form or you use false document, that's suitability. It will go against you. Or if you've committed any immigration offense whilst in the UK, that can also go against you on the point of suitability. And again, if you owe the NHS money because you've undergone treatment and you couldn't pay, you were given a bill and you still haven't paid, and so you owe the NHS £500 or more. That is suitability. So for those people who are in that situation, make sure that you contact NHS or the hospital, have an arrangement in place. Even if you are to pay £10 a month, that is an arrangement. That makes you responsible and that will not be used against you when you are applying for indefinite on the point of suitability. So let's now assume that our individual here meets all the suitability requirements, has not offended, hasn't been an overstayer and all those things, and is applying for indefinite leave to remain because next month is, or let's say next end of this year is when the person is due for indefinite, having been in the UK. So the rules say that having been in the UK for 5 years, working with an employer in that industry as a sponsored migrant worker, you can apply for indefinite leave to remain in the UK. There are specific requirements that ought to be met. So we are going to humbly ask producer to take us to the board and help us with the rule book. What do I need to have? What are the requirements? So this was updated. When was this updated?
This was updated the 4th of September 2025.
Good.
Earlier published 25th of February 2016.
Right.
Okay.
So it says immigration rules upon the skilled worker. So it's about skilled workers. And we move on down, because we are specifically looking at requirements for indefinite, which is settlement.
Okay.
So please, yes, zoom in on settlement as a skilled worker. And if you can give us bigger view or wider view. Yes.
You want it huge so we can see it properly.
Yeah.
Right.
So, Ragoku, you are going to take us through this specific requirements for our client.
So yeah, we're talking about validity requirements for settlement as a skilled worker, and SW 19.1 says a person applying for settlement as a skilled worker must apply online on the gov.uk website on the specified form, settle in the UK in various immigration categories, and the form is Form SET O. That's what we normally call it. Now, 19.2 says an application for settlement as a skilled worker must meet all the following requirements. Lawyer, with your permission, I'll go on to read.
Yes. So if we go to the first one, which is the 19.1, it simply tells you that make sure you do it online. That one, everybody knows that they have to do it online. So this wouldn't be a big deal for our client. Our client will simply say, lawyer, I know that I have to use this form. What I didn't know is that I needed to use set O. Now that you've told me, I will use set O. But I knew definitely that it had to be online. So point one is given.
Okay.
We'll go to point two.
Yes, so the point two says an application for settlement as a skilled worker must meet all the following requirements. And there are four of them. Any fee must have been paid, and the applicant must have provided biometrics when required, and the applicant must have provided a passport or other travel document which satisfactorily establishes their identity and nationality, and the applicant must be in the UK on the date of application. Lawyer.
Good. So under two, again, our client will say, lawyer, I know all this. I'm not really bothered. I know I have to look for the money and pay. I've already saved and the fee will be paid. Our client will tell us that, oh, I know I have to do biometric because the last one I did before I got a visa. So that's not a big deal. So tell me more. Our client again will say that, yes, I know that I have to add my passport. But what if my passport is expired and I'm renewing it and it's with a government authority or something, or it's even with a home office. So here, our client will want us to clarify something for him or her.
Okay.
So we'll tell our client that, right, if your passport is with the home office, then you don't have to bother because these are the people who are going to give the passport to, and they have it. They have it. However, if your passport is not with the home office, but it's missing, and you are applying for replacement, that means you cannot have the physical evidence to provide or to show.
Okay.
Or it's even expired and you are renewing. So what you do is that you have to provide evidence that you have applied for a renewal. And here, the online application you did to renew your passport from the embassy or the country you are from, you just print that. It has your application form and also the appointment confirmation. That will be replacement of your passport, and that is also fine. So that's a clarification for our client on passport.
But I have a very interesting question. In every legal document or statement, there are certain words that really matter, and you cannot ignore them. I've seen that in 19.2, it says must meet all. So it says any fee. Then there's that particular word that runs through all four of them. And so it means that if you have three and not have all the four, then you don't qualify. Does it make sense in that? Or
you must have all. And means and. So all must be available. But where you have a reason why you cannot have it, your passport is with the home office. So the law says that the rule says that if it's with the home office, then that's fine.
Okay.
That's an exemption from having it with you to give to them.
Okay.
Again, it's expired, so you are renewing it. Then provide evidence that you are renewing it. The good thing is this, that now you don't need them to put the visa in the passport. So whether they have the passport or they don't have the passport, it doesn't matter. But they want to be sure that you have a valid identity. And that's why they will ask for the passport. So if your passport expired and you've renewed it, don't panic. Just add the paperwork of the renewal application. And D is the bit. Again, we'll have to clarify for our client that the applicant must be in the UK on the date of application. What if our client is traveled and the visa is expiring today? Can they apply whilst away? D 19.2D says that the applicant must be in the UK.
Mm-hmm.
So again, we'll tell our client that please, if you intend to travel, don't, because if you are away, you will not be able to apply. So this all they know. We go to 3 then.
Okay, so we move on to 19.3 that says that the applicant must have or have last been granted permission as a skilled worker. That's a precondition.
That is important. Applicant must. So we go to 3.
So the applicant must have permission or have last been granted permission as a skilled worker.
So we can see that that is a logical conclusion.
Mm-hmm.
When you are applying to remain in the UK as a skilled worker who is due to have settlement.
Mm-hmm.
So if you have not previously been granted skilled worker or have permission to remain as a skilled worker,
mm-hmm.
then on what logical basis are you applying to remain on settlement ground as a skilled worker?
Okay.
So that is a given, but again, we've been told that this is for skilled workers. So if you have not had a visa and a skilled work,
you can't apply under this.
Exactly.
Yeah. So if you just joined us, we are actually looking at the requirements for application for indefinite leave to remain as a skilled worker. And we have looked at some of the preconditions or the conditions you must meet. The last one we touched on was that you must have had permission to be in the UK as a skilled worker. That's what we are discussing now. I know you may have other questions or other concerns, but if you have any question on this particular one, you can send that through text 0739920848, or you can put it in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV UK. Our resource person is Lawyer Charles Asma from BWF Solicitors, and he is taking us, as I said, through the requirements. So we have looked at some of the things that qualify as. What are the next steps? Let's go back to the discussion, Lawyer.
Sure. So, producer back again, help us with the rule book. So we've covered 19.3, which says that you must have previously been granted visa under skilled worker provisions to be able to qualify for indefinite under skilled worker provisions.
Mm-hmm.
19.4, what does it say?
19.4 says that an application which does not meet the validity requirements for settlement as a skilled worker may be rejected as invalid and not considered.
So if it is not, if the validity requirement, which we have already seen above, and most people will meet the validity requirement, so that shouldn't be much of a problem for our client, because our client would not be away from the UK on the day the visa expires and saying that they want to apply in the UK while they are not here physically.
Mm-hmm.
Again, our client will have all the necessary payment, the fees and all that. Passports wouldn't be an issue. So validity is met. We move on to suitability, which I have already covered. So we are not going to go back into that. Then eligibility. So we move down to eligibility.
So the eligibility requirements for settlement as a skilled worker, we're looking at qualifying period for settlement as a skilled worker, and that takes us to SW 21.1. The applicant must have spent a continuous period of 5 years in the UK. That is 21.1. 21.2 says the 5-year continuous period must consist of time with permission, not as a dependent, on any of or any combination of the following routes. A, skilled worker, global talent, innovator founder, tier 2 minister of religion, international sports person, representative of an overseas business, tier 1 other than tier 1, that is graduate entrepreneur, or scale up, or permission on any other route during the time the applicant was waiting for a decision on their application as a skilled worker, provided that application was for permission to stay and was made between 24th of January 2020 and 30th of June 2021 inclusive, and then was supported on the date of application by a certificate of sponsorship assigned by a licensed sponsor or was granted.
Okay, so at least this wouldn't be an issue. So go back, please. The first eligibility requirement, which says that the person must have 5 years continuous residence in the UK.
Yeah.
Remember, we all know that it's 5 years, then you apply for indefinite.
Okay. Yeah.
So the question is my 5 years or fifth year anniversary be the day I have to renew my visa or what? Because somebody said, if the law says that 5 years, and 5 years will not be until, for example, end of September 2025. That means I have to wait till end of September, or I can apply before. Because I wouldn't be 5 years until 30th of September 2025.
Okay.
So at what point in time within the continuum of 5-year period can I validly put in the application? We know that the standard rule is in the last 28 days. So where you have to count specific date, and if you don't meet that specific time period, you may not qualify, then you have the last 28 days to put in the application. What it means is that we are looking at 4 years, 11 months, and the last 28 days to make the 5 years.
Make it 5 years.
So in the last 28 days, you don't have to wait till the last day. You can put in counting the last 28 days, beginning or end of it, and put in the application.
Okay, so if it is the 30th of September 2025, then you can count 28 days from the 30th
down to the second.
To the second.
So from the second, for example,
you can put in the application and it will be valid.
Because then you don't. So even though it's not 5 years yet, the rules allow you to put in application for extension or renewal or variation within the last 28 days.
Okay.
And therefore, you can argue that even though the 5 years will end on the 30th of September, by putting the application within the last 28 days, it is still valid.
Okay. All right. So yeah, we're still looking at the qualifying criteria to really get us to do that. We've looked at 19.1, 0.2, 0.3, and 0.4. Is there any other qualifying criteria that we need to look at, Lawyer?
Yes. So the crucial ones. So producer, take us to the next. So of course, we've been told that it has to be any of the following categories. So that's also fine. Continuous residence requirement for settlement as a skilled worker. We are told that the aspirant, the applicant, please continue for us. No, continue 22.1.
So 22.1, the applicant must meet the continuous resident requirement as set out in Appendix Continuous Residence during the period in 21.1. 21.1 is the 5 years they're talking about.
The 5 years they're talking about.
Okay.
Yes. So, so the continuous residence, depending on which category of the visa you are on, some may be 10 years, some 5 years. And in this category, it's 5 years continuous residence.
Okay. So then it continues, if you permit me, knowledge of life in the UK requirement for settlement as a skilled worker. So the person must pass the life in the UK test.
The person must English language and also life in the UK.
Okay.
Except, of course, the exceptions will apply as we discussed
last week. Yes. Okay. And then, yes, as explained, so 23.1 says that the applicant must meet the knowledge of life in the UK requirement as set out in Appendix KOL UK. And those of you who were with us last week, we looked at some of the exceptions and they apply here. But then we continue to look at sponsorship and salary requirements for settlement as a skilled worker, 24.1. Are we looking at that as well?
Yes, so this is important. And important because all the ones we've talked about could be generic. But this will be crucial. And a lot of people may find themselves wanting under this requirement. So it says sponsorship and salary requirement for settling as a skilled worker. 24.1. What does it say?
The sponsor in the applicant's most recent permission must still be approved by the Home Office to sponsor skilled workers on the date of decision.
Full stop. So what it means is this. It says the date of decision. It didn't say the date of application. That means the person, so your aim is to look at the employer that is that you are with, and the employer must have a license. You might have switched employers, A, B, C, and this is my last employer who is taking me to the promised land, which is indefinite. Whilst applying for your visa, does this employer have license to continue to sponsor you?
Okay.
Number two, you put in application today, decision hasn't come, and before a decision is made, something has happened to the employer and license has been taken away. Will this affect you? Yes, because on the day up to the date of what?
Decision,
not the date of application. So it's important that the employer continuously retains the sponsorship license. Otherwise, it will affect you. What it means is go to then observe and understand that this employer's license is not at risk, and that even once you put in the application, a decision will be made before anything could happen.
Okay. So then we go on to 24.2. That says that the sponsor must confirm that they still require the applicant to work for them for the foreseeable future.
Let's pause there. They will go to the second one. The employer whose license is still valid must confirm in writing that we still need this person.
Okay.
We still need the worker.
At the time of the decision.
At the time of making the application. But it says that the sponsor must confirm that they require the applicant to work for them for the foreseeable future. Foreseeable future is open.
Okay.
But you don't expect the employer, you don't expect the visa to be issued to you for indefinite leave to remain, to work for the employer. And yet the job is only available for the next 6 months.
Okay.
Or the next 3 months. So foreseeable future means that you should be able to have it at least next 5 years as well. If you've had it for the last 5 years, the last 2 years, the last 3 years, it should be available in the coming years.
Okay.
Here you can see that there is room for maneuver because it says foreseeable future. What is foreseeable future? Foreseeable future could be, so simply means that the job should still be there. And there should be no inclination or nothing to suspect that the employer's license will be taken and so the job may not be there. Let's assume that once you put in the application, the employer is under investigation. Then the job will not be available in the foreseeable future. May not be. So everything must be set out clearly, and the confirmation must come from the employer. So if the employer is going to confirm, the employer must do so in writing. So how can you, a client who has come for legal advice, apply for indefinite leave to remain simply because you've been working for this employer and yet there's no guarantee that the job is going to be there or is there? Then the employer will not write anything for you, because you want an employer that will guarantee, must confirm in writing on a headed paper.
Okay.
So let's bear that in mind. That means the employer must be aware that you are due for your indefinite leave to remain application. They must confirm that they still need you, and they must confirm that the job will continue to be there even after getting the visa. In the second part.
Okay. So let's go to the second part of the document, which talks about 24.2.24.3. The sponsor must compare. I think that's what you have alluded to.
And the second part to that part.
Yes. And will be paid for the foreseeable future, at least the salary in SW 24.3.
There are two things after and. One, the applicant is paid. And two, the applicant will
be
paid.
Okay.
So is paid means that
you are in
employment, you are on payroll, and you are getting salary. How are we going to verify that?
Your pay slips, your contractor, the letter
at large. How are we going to verify? If we want to extend the investigation, who will we go to?
So go to the employer.
The employer would give you all this.
Okay. So
HMRC.
HMRC, yes. That's the point.
So by extension, HMRC will verify for us, for the Home Office,
whether you are being paid that amount.
Whether you're being paid.
Okay.
So if you are not being paid currently, then you cannot apply for indefinite.
Okay.
Maybe you are doing voluntary job, so you're not getting paid,
or even paid less.
That is why it says that if you are being paid and you will be paid, then it must be at the salary threshold.
Okay. And that's what is stated in 24.3.
24.3.
Okay.
So 24.3.
So let's look at the threshold of the salary. A, all cases where rows B to E do not apply, salary of at least 41,700 per year.
So for the salary conversation, when there's so much technicalities in there, we are not going to go. But all we are saying is that if you are being paid, you are on payroll, you are receiving your salary every month, then the employer must confirm, or you must provide evidence to show that you are getting paid. And number two, you must show that the job will continue and that your salary will not change from what is specified under 24.3. And if you are getting paid, then it will still be because then the foreseeable future, what it simply means that within these categories, whether it's 41.7, 33.4, whatever, depending on the category of SOC you are on, you should be able to prove that the salary will not at least go down from what you are getting.
Okay. And if somebody wants to clarify or verify where they are supposed to be on the salary list, where do they go? Can they just consult a lawyer, contact a lawyer to get that?
So this requirement is available online. So once we type appendix skilled worker, the provisions will open. You go through, look at specific thing you are looking for. Because we are discussing settlement as a skilled worker, we went for settlement application requirements. And these are the things that if you are doing it yourself, that's what you have to be checking. But if a lawyer is doing it for you, that is why you have sold your problem to the lawyer. The lawyer must bear and carry the cross for you. So the lawyer will then check to see whether the requirements will be met.
Okay. So having met all these requirements, I guess we're looking at...
So move on down to the next one. Yes. After the table. So just up. Okay, there. 24.4.
Okay. So 24.4 talks about salary under the table in 24.3 is subject to
certain conditions.
Yeah, so those conditions.
So let's leave the conditions out.
Okay.
And go to if the applicant is absent from work.
So if the applicant, that's B, if the applicant is absent from work for one of the following reasons set out in part 9, paragraph 9.30.1, or has returned from such an absence within the month before the date of application, consideration will be based on their salary on their return to work as stated by their sponsor.
Good. So it's like, what salary are we going to use to analyze? Largely your last salary before your application. What if you were on holiday and you were not, for whatever reason, paid? But if you're on holiday and it's leave, then you must be paid. Because being on leave doesn't mean you are not working. Yes. But if it's about any other thing and there's no proof that you received a salary in the last month that you are away, then we have to look at the second part where it says that so on that basis, what do we look at? It says that on their return, so the salary on their return to work as stated by their sponsor. So the power is given to the employer to confirm their salary upon return if they had been absent in the last month before the application was put in.
Okay.
Then, if this is the case, what will the caseworker finally consider before granting or refusing? 25.1.
So decision on an application for settlement as a skilled worker. 25.1, as lawyer has pointed out, states that if the decision maker is satisfied, all the suitability and the deliverability requirements for settlement of the skilled worker are met, the applicant will be granted settlement. Otherwise, the application will be refused.
What is the operative word for granting? I mean, for it to be granted, it says will.
Will.
So if my client has met all the requirements,
so it's more of a tick box.
Tick box exercise. It's mechanical.
Okay.
And that's why you can analyze and see that you qualify, you don't qualify.
Okay.
Because you want to apply for indefinite. You are on payroll, but you have nothing to prove that you are on payroll.
Mm-hmm.
You are receiving payslip, but the money doesn't go to your bank account. So you are not working.
Okay.
So if you don't have the evidence, then you'll be marked down under one of the requirements. In this case, the application will be refused. Okay. But if everything is ticked off, application will be granted.
Okay.
So let's assume that for whatever reason, Home Office has made the caseworker has made a mistake, missing the analysis of the checklist,
okay, and
refused. I will then point it out to the caseworker that the rules say A, B, C, D, E. Take. Applicant must be refused under SW 25.1. Everything is ticked if must be granted. Everything is ticked if refused, and therefore you did not apply the rules correctly. Mm-hmm. You have to fix it.
So that remedy is given in 25 too, I guess.
So it says that what did you say?
If the application is refused, the person can apply for an administrative review under Appendix AR, that is administrative review.
Yes. So if you think that you've been refused, but you only go for admin review if you are 100% sure
that there was a mistake.
The rules were met, and yet the caseworker misapplied it.
Okay.
Because if they were met, then the application, the visa will be granted. But if it wasn't, the visa will be refused. But if it was met and the caseworker refused it, then the caseworker has procedurally erred. And so we have to have the application decision reviewed. So before you go for review, you must hold something great in your hand to show that you've made a mistake. This is it. You didn't follow. Because it says that the employer must confirm. My employer brought a letter.
Okay.
So if you are not happy with the letter, who should you go to?
Go back to the employer.
Don't punish me.
Don't punish me. So then, in this case, as you said, is a tick box exercise. I qualify under all the eligibility requirements, and then I have also provided every document that comes in. I need to pass my English language. I need to pass the Life in the UK test. That is the knowledge of life and language in there. When all these things are done, I need to go online and put in the application. I've done that. How long does it take to come out?
Yes. For me, I always say that put it in, move on with whatever you are doing, because the rules say that the job must be there for you. Mm-hmm. And so if you are putting application and you are waiting for a decision, the job will not be taken away. So you continue to live your life. The only reason why you may want to have it now is to travel on an emergency. Mm-hmm. In this case, you have to provide a need to travel to attend to that emergency, mm-hmm. and they will have to expedite a decision. All I'm trying to say is that it takes a bit longer, mm-hmm. but if it's not in, nothing to worry, provided everything is on course. Otherwise, you must have a reason why they should expedite decision on the application. And this will be on the basis of ill health or death of a family member.
If you just joined us, you're live with us on BWTV, and we have in the program The Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors is located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London, N15 4NP. If you're coming by public transport, especially the train, you take the Victoria line, alight at Seven Sisters, use exit number 2. It will bring you to the frontage of the Anna House. Climb up to the 4th floor. They are there Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on the 0208 493 7340. Or if you're in Ghana, you can call 055 589 5959 or 004477 127 61884. BWF solicitors are trusted partners when it comes to the law, and they are bringing us this very wonderful and very informative program, The Community and the Law. Our resource person this afternoon is Lawyer Charles Asma. We're taking a quick break, and when we come back, we'll take your concerns, your questions, and then also if there's any other further explanation to the whole topic, that is indefinite leave to remain application requirements for skilled worker migrants. Lawyer Asma will help us do that. Don't go away. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. We're live on BWTV UK, and we are on the social media platforms at BWF Solicitors on Facebook, at BWF Solicitors YouTube, and BWF Solicitors BWTV UK, sorry, at Facebook and YouTube. Indefinite leave to remain application requirements for skilled worker migrants. That's what we've been discussing. And our resource person, Lawyer Charles Asma from BWF Solicitors, has graciously taken us through what the requirements are and how to put in the application. I believe that you are kind of empowered to be able to put in the application yourself. But if you need any support, any help with that, or you go by my saying that it's always best for a layman to give their work to an artisan to do for them, you would have to go to BWF Solicitors and get them to put in your application for you. What we ended on was that if the tick box exercise is completed and you have met every criteria and still your application is refused, you could go, or there's a remedy, you could go for an administrative review as stipulated by the guidance and the process. Now the lines are active: 0208 493 7345, or you can send a text or WhatsApp to 0739920848, or leave them in the comment section down below. I'm here together with lawyer Charles Asma, and we have your questions to answer. Let me recognize Andrews Nyako, you are online with us. Daniel Upon, you are here. Frida Fad, you are online with us. Sandra Fraser, as usual, you are here with us. Ohima Messi, you're watching with us. Thank you very much. Mami Amaforiwa, Bill is watching. Thank you. Clement Ewa, you're watching. Thank you very much as well. And we have Adeshina Adenike. You are also watching. Nanaba Foriwa, thank you for doing that. Danny C. Woods, you say thank you, or please can you apply for indefinite when your first renewal, when you do your first renewal? I'll throw that first of all to lawyer Asma to start it off with us. Can you apply for the indefinite when you do your first renewal?
So the story is not complete.
Hmm.
Can you apply when you do your first renewal as what? Under what? We're discussing skilled worker. Is this about skilled worker? Renewal after your first 1 year, renewal after. So, Danny, it's not complete. Can you please provide more information to enable us advise you clearly and properly?
Okay, so Danny, yes, if you can get us more information, that would be very beneficial. Let's pick up the next one and say, um, good afternoon, last one, everyone. Hope you're doing good. Yes, we are very well, thank you. You have an indefinite leave to remain, and you're now full-time student at the university. You're studying adult nursing. So if you're not able to work due to placement, can you bring your wife or a partner? If yes, what would the requirements be?
So I have indefinite leave. Okay. I'm now full-time student. I'm studying. Okay, it doesn't matter what you're studying. I'm not able to. Okay, so it might be that the person's question is mainly under financial requirement. Can I bring my wife if yes? What? So if you are not working and you cannot provide evidence of income, then you are not able to meet, or that's your wife. Your wife may not be able to meet the financial requirement threshold, which is 29,000. So, but if your wife herself is working and earns up to that amount, then it's likely. There's also savings threshold, but I'm sure if you're not working, then savings might not be an option for you. So, our brother who shared this with us, I want to request that you get in touch. Let's look at your peculiar situation and analyze it to make sure that either you need extra time, we look at what your wife is doing and how much her income also is. Then we can look at the best time to put in the application. So on this occasion, we cannot say yes. And because we cannot say yes, what will be the what requirement? We cannot provide. But if the requirement, then the requirement will be inclusive of earning 29,000 before tax a year. And that is the bit that is at stake. Otherwise, I'm sure you've met all the rules.
Keep them coming through. If you want to send a text, 0739920848, or you keep them in the comment section down below, as Daniel has done. Daniel Paul says, if I may ask, how long it would take for priority service if you apply for indefinite leave to remain, please, and how much would it cost? Priority application.
Normally, with indefinite leave to remain, you don't see the priority there, but there was a couple of them that we did. When we got to the payment stage, there was priority. Priority is usually extra £1,000 to the standard fee you have to pay. So if there is priority opportunity for you to select, then you pay extra £1,000.
Well,
they say how long?
How long? Yeah.
For the priority. Priority is usually within a week. to be decided?
Well, straightforward answer there. Yes, quite easy. If you need any further help and clarification, you can contact BWF Solicitors. Or if you want to quickly give Lawyer Charles Asma a shout, you can get his number or get him on this number 07947 63 60 37. 07947 63 60 37. Now let's keep your questions picked up. If you want to call us, you can call us on the line. The lines are active. Yao Evans says, "I want to bring my mother-in-law for a childcare purposes. She's not working, so wouldn't be able to get a bank statement. What documents would I need together to be able to bring her?"
So the thing is, you cannot bring your mother-in-law for childcare purposes because that is work visa. So she's not coming for childcare. She's coming to visit the family.
Mm.
When she's here, what she does, including holding the baby, is normal family duty. But she's not coming because of childcare. Now, what does she need to be able to apply for family visitors visa? She has to show that she will return after the visit. So there should be what we call genuine visitor assessment carried out by the caseworker. And once that is done, your mom should be able to pass the assessment that she's coming to visit. She will go back to her country. What is happening or what is she doing to suggest that she will hurriedly return after the visit? That is crucial. So it's not as for the bank statement and other things. Um, Bring her. It says bank statement. What is it able to what? So she's not working. So if your mom is visiting you, she doesn't necessarily have to be working. So you are sponsoring your mom. So everything will be on you. However, she must show that she will return to the country where she's coming from to continue her life, i.e., what is the role she's playing. If she's not working, she might be a church leader, very prominent person within the community. Her influence, her contribution, so important that they cannot afford for her to stay away from that country. So, what's the evidence? And what is so important that she cannot be away and she has to return to? Is it about church? Is it about the family, community, anything else? Again, there are some people who may be on pension, and as pensioners, sometimes they have to go on holiday. One of them may, coming to visit the family, or the child that we are talking about, we are going to have the dedication or christening, and mother of the parent has to be there, or the child grandparent has to be there. It's even possible that this child is named after this grandmother who is coming. Wow, I'm attending the naming ceremony of my first grandchild, my second grandchild, doesn't matter, of my grandchild. My grandchild is named after me, and so it's an honor to be there, and also more important for the family that I am present for this occasion. And I will return as soon as this event is over. So it is the argument supported by personal circumstances in the country that matters.
Okay. So we keep on bringing your questions and concerns up. Let's see which one is next. We have J. Carmo. Can an EU person settled in the UK renew his passport in his home country? If yes, what implication can it have on further applications in the UK? For instance, Italian in the UK.
So you are in the UK as an Italian citizen. Can you renew your passport? Of course you can. Where should you do it? Italian embassy in the UK. Will it affect your visa? It doesn't have any adverse bearing on your status.
Well, thank you, Chikamo, for your question. Thank you for your lawyer for the answer as well. 0208-493-7345. That's the studio telephone number. Or you can send a text or WhatsApp on 07399208-468. 07399208-468. Or easily leave it in the comment section on Facebook at BWF Solicitors and at BWTV UK, and also on YouTube at BWF Solicitors and at BWTV UK. Next, we have this. Veronica Kunedu, please, I have been married for 4 years now. I have divorced. Can I have my indefinite without my husband's contribution? I'll just kind of put it in a way we cannot understand.
It depends on what sort of visa you are on. If it's EU, then you can apply under retention of right provisions within Appendix EU to the immigration rules. If it's not, you came under your husband who has indefinite leave to remain, from a foreigner with indefinite leave to remain, or who is a British citizen, then the divorce will affect your subsisting relationship, warranting your ability to apply for indefinite leave to remain. So the answer will be yes if your indefinite is going to be applied under EU rules. If it's not under EU rules, then it will be difficult because you still have to show that there is subsisting relationship with your partner who applied to sponsor your initial application.
Keep on coming through. Veronica, thank you very much. We pick up the next one, which is from Clement. Do I qualify for indefinite leave to remain when my main employer refused to give me work for the first 4 months of my 5-year sponsorship?
So the beauty of this is that the rules say, as we went through, it says that the last employer should be able to confirm that you are working for them, the job is going to be available even after the visa is issued, and you are getting paid, and you will continue to be paid after the visa. So it is the last employer. So if the first employer, blah, 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 the last employer will have to be the one providing all the things you need.
Client, thank you for that. Laura, thank you as well for it. The next one is from Liz Rosehill. Please, if a non-EU dependent got a family member or became a family member, I think that's what you mean, in 2017 and was granted pre-settled in 2021 and now wants to make a retention of right application but got divorced in 2018, what could be done in this situation, Laura?
So let's analyze.
Yes.
So married, got married, I suppose, and became a family member in 2017. So 2017, this person is a family member. Was granted pre-settled in 2021. How could you be granted pre-settled in 2021 if you had already divorced in 2018? Maybe it's the other way around. That got indefinite in pre-settled in 2018, divorced in 2021.
Okay.
Because if you were granted indefinite pre-settled in 2021, when did you apply? And how long did it take? So I want to believe, Liz, come and tell us, is it the divorce that is 2021 or the pre-settled status that was issued in 2021? That will help us to understand your case better. However, let's assume that it is the case that you were given a pre-settled in 21 and you in 18 and you divorced in 21. So currently you are divorced, but your pre-settled will expire soon. You'll be able to apply under retention of right provisions because once you had your pre-settled status, the relationship broke down and there has been a supervening event, which is divorce. So you have to provide evidence that you were living with your partner up to the date you separated, continuing up to divorce. You don't have to bother after separation and divorce. But before separation and divorce, you must provide evidence that you were living together.
Any further help, you can contact BWF Solicitors and they will readily offer that for you. Keep them coming through. If you have a text, 0739920848. Kwajo Citizen, it says, I applied for an EU family member permit after spending a year in the UK on a skilled worker visa. Unfortunately, my EU application was refused and I subsequently submitted an administrative review. Currently, when I check my immigration status, it states that I am awaiting a decision on my EU application. I'd like to know what will happen if I withdrew my administrative review. Would I be able to return to my previous skilled worker visa status? So he is caught in two minds. And I would want to ask before you go on to this one that can a person have two different uh, status in the UK at the same time?
Obviously, you need one, but the point is this. I'm actually going to ask him whether, whilst waiting for, before the person applied for the EU visa, they had the skilled worker visa valid. And two, whether, as we speak, the skilled worker visa is valid. Because if, as we speak, the skilled worker visa is not valid, if you withdraw the admin review, which is holding you because of the certificate of application, then you are out completely.
Okay.
But granted that you applied for this and you have this also running, and that is where normally it's a bit of, because when you are applying, they don't ask you whether you have whether you are exchanging this for the one you have. They normally will ask you, do you have a application pending? You can exchange the application that is pending with the one you are making. So if they don't ask you whether you want to exchange what you are making, the application you are making, with the visa you already have, then the presumption is that you had your skilled worker visa, you were switching to EU visa. If the EU visa doesn't work, you go back to your skilled worker because you still have a visa. So that is where people who can say that once EU is granted, the person will then say that this is what I have. So it becomes sort of, but if one is refused, and because the rule doesn't say that if you apply, we are exchanging it with what you have, then if you are refused, they wouldn't say that you can't go back to your visa. But we don't even know whether the skilled worker visa the person was on is still valid. So what's the name? Is it Clement? Oh, Citizen.
Citizen.
So Citizen, if you can come back and tell us whether your skilled worker visa is still valid, then we can advise you fully on whether you can consider withdrawing the admin review or not.
We still have time, so you can drop that in. Or if you have a new question, just drop them on the comment section down below, or send it via text, or call in to do that. Let's pick up the next one and give it to lawyer for us to have an answer. Ellis says both partners have till 2026 November for their visa to expire. The main applicant will have 5 years by June 2026 to apply for indefinite leave to remain. Can the dependent still be on the same visa till it expires in November, by which time he would also apply for indefinite leave to remain in the same month, November?
Right. So the main applicant will have the 5 years due in June 2026. The reason why the dependent may have his or hers extended or in November is that when the caseworker was issuing the visa, instead of issuing up to the date the main applicant visa expires, they had a grace period for this person, luckily. But it doesn't take away the fact that when the main applicant is going forward to apply for indefinite leave to remain, the dependent must be tagged along. So you can't say that my main applicant is due for indefinite, but I'm waiting. You cannot apply on your own. You have to apply together with your main applicant.
Apply together with your main applicant and things work for you. You could be tagged along, as lawyer has said. 0208493735. Citizen could just come back. He says it was valid at the point of application, but currently don't know my status since it says I'm waiting for a decision for my EU application.
All right. So if you don't know your status, then you can't say you have a skilled worker. What it means is that potentially what has the application you made, the EU application you made for which you were issued with certificate of application has over reading any other ones you had. Or it's also possible that a skilled worker has been terminated as a result of 60 days that you were not even aware of. And because of that, what you have on the system is the EU visa, which is on admin review. In this case, you have to ask yourself, if I withdraw the admin review, what can I do? You cannot make a new application under work visa. You can apply under family rules. But if you feel that the delay, yes, is delayed, but you're still working because you have your certificate of application, which is still valid, and you are using it to live your life in the UK, then be sure what you are moving on to before you withdraw.
A word to the wise is always enough. So keep that in mind, Citizen Kwedu, for that one. We're moving on. Remember, we have the quiz that we have to look at later on before we draw the curtains down. We have given you our nugget, and we have had our discussion on indefinite leave to remain application requirements for skilled worker migrants. We'll take this quick break and come back to pick up your questions, concerns, either on Facebook or YouTube at BWF Solicitors and at BWTV UK.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. We're live on Facebook, YouTube at BWTV UK and at BWF Solicitors. Your lines are active 0208 493 7345 or 07399208468. You can send a text or WhatsApp or leave comments in the comment section down below as we are live. We have been discussing indefinite leave to remain requirements for migrants on the skilled worker route, and Lawyer Asma is taking us through all that. Now, earlier on, I gave you the nugget, and I believe I would be okay to remind you of that. And I asked you the question, did you know that there is an exception for those who have overstayed for 14 days or less and sometimes a few days more? If your visa expires whilst you are still in the UK, you will become an overstayer immediately. However, there is an exception contained in paragraph 39E1 of the immigration rules. This exception means that you must still be able to make an application for leave to remain, subject to both of the following conditions. And I've given you those conditions on the screen. You must have the new application within 14 days of the expiry date of your previous grant of leave, and you must have a good reason why the application could not be made on time. As I said, is based on paragraph 99E1 of the immigration rules. That aside, I also asked you a question based on the scenario, and I was asking whether a person or friend in this scenario could apply for further leave based on the COS despite a visa expiring on 21st August. So let's look at what the situation is. Agatha Mumford came to the UK as a skilled worker with a visa for 3 years from 2023 to 2026. She received an email on June 21 from the Home Office stating that her visa had been revoked. Her visa was cancelled to expire on the 21st of August, that is 60 days from the 21st of June. Before this cancellation, she had received a conditional offer from the NHS pending completion of pre-employment checks. She received a certificate of sponsorship from the NHS on the 4th of September 2025. So then I asked the question, can she apply for further leave based on the COS despite her visa expiring on the 21st of August? Three options I gave you. Yes, because the NHS is a government employer, so its employees are covered. Could it be B, that she cannot apply because her visa was cancelled to expire on 21st of August, so she is an overstayer? Or could it be C, that she can apply because she made application within 14 days and she had a good reason for the delay? Think about these. But then I will go back to the questions and comments that you have either on Facebook or YouTube, and I will get lawyer Asma to address them. Mavis comes up with this one. When your indefinite application visa is due over 6 months of application without any information from the Home Office, what should one do? I think maybe you are asking whether you put in the application and after 6 months there's no information from the Home Office. What would you have to do? Lawyer.
So when declaration is due over 6 months probation without any information from the Home Office, what should you do? Right. Okay, Mavis. So Mavis, I know you're asking about your application. Yes. So we usually follow up. We have followed up, and we have not heard from the Home Office yet. There are a lot of applications currently before the Home Office. What we do is to follow up, and what they tell us is that they have administrative or operational issues, backlogs, and so on and so forth. So we can only wait. So, Mavis, yes, we are still waiting for your decision. Okay. Soon as it comes through, we will let you know.
So still waiting for the decision, and when it comes to definitely the obligation is to get you to know. Thank you, Mavis. Keep your fingers crossed. Now, does it mean that someone who has overstayed before but has regularized his stay and has indefinite cannot become a British citizen?
So does it mean that someone who has overstayed before but has regularized the stay cannot become a British citizen? No. Where did you get this from? Because this wasn't part of the conversation. But if you say, does it mean? It means it's what we are saying, suggesting that X, Y, Z. But that is not what we've discussed. Are you asking this question because of the provision that came in February 2025 that if you came to the UK illegally, you cannot? I don't know where you got your context from. But if the person entered the UK legally, it doesn't matter whether they overstayed or not, they can still become British citizens. So, Nana, if you can come back with more story to let us understand where you are coming from, so that will also be clearer in our response.
Okay, all right, yes, let's keep it going. I think we will take the very last one. Emmanuel Atakra. Is this, can two people on certificate of sponsorship, whether a dependent or the main applicant, marry in the UK without going to Ghana? Can someone giving 70 days to leave the UK marry someone on a certificate of sponsorship in the UK without going to Ghana? So what I can't decipher is you are on a certificate of sponsorship. Another person is on another certificate of sponsorship. You have met, you love each other, and you want to get married. If that's possible, would you have to go to Ghana? Or then the next one is a separate question, so to speak. You've been given 60 days, not 70 days. I think the standard is 60 days to leave the UK. Can you marry someone who is on a certificate of sponsorship without going to Ghana? Lawyer, I think this is a two-tier question.
Right. I mean, if you both have, it's a whether a dependent or main, two people, whether dependent or main. So if they are both main applicants, of course you can marry. But if you are marrying because you want one to sponsor the other, then I don't see why you want to do so, because you are both on a visa status that allows you to live your life. Unless, of course, one want to become a dependent so that they can work unlimited hours in any industry. In that case, obviously, there will be questions to be asked whether the particular industry allows this person to switch to join the spouse or this main person, and so on and so forth. Now, in terms of getting married abroad, can you marry abroad? Yes, you can, depending on the country and whether. Oh, it says Ghana. Okay, so it's specific. Without going to Ghana, yes, you can. Under Ghanaian marriage rules, you can obviously ask your family to represent both parties at the marriage ceremony, because under Ghanaian customary marriage provisions, you do not necessarily have to be physically present. But even if you are physically present, it is usually the case that the two families will meet, have the conversation without you. They will call you from outside. They come in. This flower has been brought here. Should we accept it or not? And all this. So that is normally what happened. The dowry system. So whether you are away or you are in Ghana or wherever you are, it doesn't really matter. So the customary marriage provisions, provided you meet all the requirements, allows for families to represent. So you don't have to be physically present. So that is the second question. For the first question, it depends on the circumstance. I suppose you need direct or face-to-face conversation or one-to-one conversation so that we can probe more to understand the context of the first question. Okay, Emmanuel?
So, Emmanuel, I would wish that you, as lawyer has suggested, you came through. If you want to talk to him directly, 07947 63 60 37. You can speak to lawyer Charles Asma directly, or you can call BWF Solicitors directly, 0208 493 7340. Book an appointment and come over and speak to the lawyers. Now, this afternoon, we've looked at indefinite leave to remain application, the requirements for those migrants who are on the skilled worker route. We've looked at the conditions, we've looked at what you need to satisfy, and then what happens when your application, if erroneously refused, the remedy that's given you. And we have also taken time to answer your questions and address your concerns. Last my still here, but we are going to get you tested on the scenario I gave you. And my dear, get me the answer. Is it one, two, or three? We're asking whether our friend in the scenario has the right to or can make any application based on the situation. We're taking that quick break, and when we come back, I'll take you through the scenario again, and then I'll pick up your answers. It's still the community on and the law right on BWTV UK, and brought to you by BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. We're doing the last leg of the program this afternoon, and that's where we go to look at our quiz scenario and ask you to help us answer that. So Agatha Mumford came to the UK as a skilled worker with a visa for 3 years from 2023 to 2026. She received an email on June 21 from the Home Office stating that her visa had been rebooked. Her visa was cancelled to expire on 21st August, 60 days. Now, before this cancellation, she had received a conditional offer from the NHS pending completion of free employment checks. She received a certificate of sponsorship from the NHS on the 4th of September. I'm asking, can she apply for further leave based on the certificate of sponsorship despite her visa expiring on the 21st of August? Then the three scenarios are yes, she can, because the NHS is a government employer, so its employees are covered. No, because her visa was cancelled to expire on 21st of August, so she's an overstayer. And then yes, because she made her application within 14 days. She had a good reason for the delay. Now, I've shown you this 3 times already, so keep giving me your answers. Let's see what you have. Kojo Citizen says is the third one. Yes, because she made an application within 14 days and she had a good reason for the delay. Thank you, my friend. The next one says Joycelyn for, well, you said number 2 or B. Okay. No, because her visa was cancelled to expire on the 21st of August. So she's an overstay. And Anapoku says it's B. No, because her visa was cancelled to expire on the 21st of August. So she's an overstayer. Florence Boachi thinks is the first one. Yes, Agatha Mumford can apply because the NHS is a government employer, so its employees are covered. Alexa Mwako also thinks, saying that because NHS is a government employer, its employees are covered. We have Kujo Daniel says, Agatha can apply because she made her application within 14 days. She had a good reason for the delay. C. We go on to the next one, which is from Andy Boache. And Andy Boache thinks that is no, because her visa was cancelled to expire on the 21st of August. So she's an overstayer. Martha Opon thinks same. No, because she is an overstayer. The visa expired. Nana Richard thinks is number 3, which is C, because she made her application within 14 days. She had a good reason for the delay. We have Priscilla Entry thinking that it's number 1 because NHS is a government employer, so its employees are covered. Prince Saki thinks same. NHS is a government employer, so its employees are covered. Barry Asamoah thinks so. Barry says that yes, because NHS is a government employer. James Appiah also thinks C, because she made her application within 14 days, she had a good reason for the delay. I'll just take one more answer if there is. Then I'll go over to lawyer Charles Asma to help us answer that. Tilly Duma says it's number three because she made her application within 14 days. She has a good reason for the delay. Lawyer Asma.
All right, so the nugget is clear. Paragraph 39E, 1 of the immigration rules. If you are late to submit an application, you must do so within 14 days, but you must provide a reason. Our client was late, and it's actually the last day, which is the 14th day, is when she got the COS to apply. And what was the delay? Is it something that was within her control or outside her control? It appears that it wasn't within her control because the employer was pursuing the COS
Employment checks.
employment or pre-employment checks. And pre-employment checks are conditional matters for the employment. And so if there will be a letter from the employer to confirm this and that will support the reasons why the application was not submitted on time, but within 14 days. And therefore, she will be able to submit, and C is the answer.
So C is the answer. Yes, as lawyer said, there's an exception contained remember we talked about paragraph 39E1 of the immigration rules, and it means that you may still be able to make an application for leave to remain subject to both of the following conditions. Remember, we looked at that in the nugget that you must make the new application within 14 days of the expiry date of your previous grant leave, and that you must also have a good reason why the application could not be made on time. And this time, as lawyer explained, there was a reason, yes. The plausibility of the reason was whether the reason was outside your control, which of course was outside their control, and the credibility of it. Yes, the employer, which is the NHS, was doing pre-employment checks. So obviously, well, they needed to do that, and there was nothing their friend could do. So that brings us to the point where those who said it was E were correct. Tilly, I know you're making nice about that because you got it correct. Thank you very much, all of you, and thank you for even giving it a try. Same time on Monday, before noon, our nuggets will come out, and we'll put the question in the mix over the weekdays, and you can check from our social media handles what there is. And on Saturday, when we come back on the program, you'll be able to put in your answer to check whether it's correct or not. So thank you for participating. At this point, yes, I will come back to Lawyer Asma for him to help us with a summary of what we discussed this afternoon. Just to remind you, we looked at indefinite leave to remain application requirements for migrants who are on the skilled worker route. Lawyer Asma.
Right, yes, we did. Looking at a requirement for somebody who wants to apply for indefinite leave to remain as a skilled worker. So we understood that you must have lived in the UK for 5 years as a skilled worker, and you were last granted leave under skilled worker provisions. The 5 years must be a continuous residence, and therefore you must show that it is up to 5 years. However, you can apply within the last 28 days or to the 5 years. The next thing is with the job itself. One, the employer must confirm that they still need you. You are with them and they still need you, and that the job will be available even after the visa. And the next thing is that you are getting paid now and you will continue to be paid at the salary threshold level specified under paragraph SW 24.3 of Appendix Skilled Worker. And we've also touched on the fact that the categories include skilled worker or general workers and so on and so forth. And for those of you who are under the care route, 6135, 6136, before it was 6145, 6146, most of you are due for indefinite leave to remain. The most crucial thing is that you have to be in the UK to apply for the indefinite. And the next thing is that your employer must write to confirm that you are still needed and that the job is available and that the job will continue to be available and that you are getting paid at the right salary level and that you continue to be paid at the right salary level and the employer's license is still valid and intact. If you're able to prove all this, you are more than likely that your visa will be granted under paragraph SW25.1 of Appendix Skilled Worker to the Immigration Rules. This is what we had for you.
Fantastic. It was a very lively discussion, and I appreciate your contribution and your participation. You would realize that today is the last Saturday of the month of September 2025. Next week, we would have entered the new month. Now, let me go back and say, those of you who celebrated your birthday in the month of September, we put you all together and say thank you for that. And we would want to celebrate Abigail. We had our dear mom, Cynthia Brown, also celebrating her birthday in the month of September. And I think we also had another one in September. Okay, well, at least we got these two. Yes, Batman Rodriguez celebrated his birthday. That's our design man. Yes, no, I remember that when he refused to give me his poster, but I got this one and I put it on there for you. Congratulations to all of you and to our employee of the month of August 2025. That was Madam Cynthia Brown. We say congratulations to you. And next week, I know definitely we might be coming up with the person who got the employee of the month, September 2025. And also remember, we are going to the pink month where we will be looking at breast cancer for our dear ladies, moms, and friends and sisters and everyone. So we will be creating some awareness as well as celebrating Black History Month. So on this program, we will be highlighting some of these things and also concentrating on all the updates that will come from the Home Office as far as our immigration stuff are concerned. And also any legal issue that will come up that we need to update you or educate you on, we will be doing that. So let's say thank you to BWF Solicitors for their kind sponsorship of this event. And for today, I want to say thank you so very much to Lawyer Charles Asma for his time. The effort is put in to prepare, to educate us and empowering us. And to the BWF Solicitors family, we want to say thank you so very much because without you, we wouldn't have had the opportunity to do this for our community. So on behalf of the production team, to Lawyer Bernard Owusu, Lawyer Eunice Champo, Lawyer Charles Asma, Lawyer Annie, and the Chinese solicitors and everybody that is part of the BWF Solicitors family, both here in the UK and back home in Ghana. We want to say thank you very much. We appreciate your effort. And to you out there, without you, we don't have a program. So I would urge you to keep liking the page, keep subscribing to it, keep sharing and inviting people to come join us. And I want to invite you to come join us again, same time next week for another edition. So my producer, Professor Adair, the indefatigable, and to my admin person, Sheila Ankara, and to Padmo Dudu, our aesthetics man, want to say on behalf of all of them, thank you for your time this afternoon. My name is Ulrich Frimpong. Good evening.